notre prochain intervenant.
Our next person, Mr. Koen Muylllе, will tell us about political ethics, separation of powers in Belgian law. Since 2015, he's been state councillor. And before that, he worked for the Senate, the Parliamentary Assembly of Europe, and as a legal advisor of the Constitutional Court. He's also a member of the Institute of Constitutional Law at 𝐸𝐿ouvain and Constitutional Law and Parliamentary Law, and he's a co-author with Mr. Van der Rust, which is the reference in Belgian parliamentary law. So it was translated in French by Louvain in 2023, and he's the author of many articles on parliamentarian life and on many articles on parliamentary law. And today he's going to tell us about political ethics and separation of powers in Belgian law. Thank you, Madam Chair. So I would like to thank the organizers for their invitation. It is an honor for me to address this high-level audience. As the chairwoman said, I've been working in the legal department of the Parliament, and now I work from the State Council and for the ethics in politics. So you can understand that this double hat has strongly influenced my analysis of ethics. I was asked to tackle ethics and the separation of powers in Belgium, and especially the parliamentary ethics in its connection to the separation of power that I will focus on today. So there's no real case law on this, and this is the consequence of the separation of power and the parliamentary autonomy. So there are very few articles, and the only department who did a critical analysis on the separation of power and ethics, that's the Council of the State, which has to deliver rulings on draft law and draft regulations. And for our foreign guests, all these rulings compose what we like the list of the State Council. So since we're talking about ethics, I would like to say that the rulings that I will mention are rulings in which I was not party. So I'm going to do quite an empirical description illustrating the links between parliamentary ethics and the separation of powers. And I think that there are two ways to tackle this issue, and especially the second one that needs our attention. So I will present the first one very briefly. First, we need to see that ethics can or cannot contribute to the respect of the separation of powers. And I would like to illustrate this by telling you about two cases that took place in not so distant past. I hope you could read this. In 2005, in the press, it was said that Anne-Marie Lizin, who was at the time the chairwoman of the Senate, had written 2 letters to a magistrate in a divorce case that she had to rule on. And at the time, the Senate didn't have a code of ethics. But the Assembly decided to organize a debate on these facts. And during this debate, the chairwoman recognized that this was a mistake incompatible with the principle of the separation of powers and presented apology. And then the Senate adopted a resolution that's on the screen in which it considered that the chairwoman had made a mistake. And after noting her excuses, requested the setting up of a special commission in charge of drafting the rights and duties of senators in their duties. Even though this is not a formal sanction, this could be considered as a criticism of this chairwoman. John Combe at the time he was president of the Flemish Socialist Party, called a youth judge who had to make a decision on the custody of 2 kids. Following this contact, the judge informed the first president of the Court of Appeal of Anvers, who seized the Ethics Commission of the Flemish Parliament. And the commission considered that the MP had not made a mistake and only held a person who was in contact with justice. Even though Article 9 of the Code of Ethics of the Flemish Parliament bans any intervention in judicial proceedings. So for the question we have to tackle today, I have mixed feelings about this result. In one case, the Assembly could react appropriately despite the absence of a code of ethics. And in the second case, there was the presence of a commission of ethics and a code of ethics. This did not prevent the Assembly from reaching a disappointing conclusion. A second way of analyzing this issue today is to check how the separation of powers has shaped the way ethics has been developed. And as you will see, this is focused on the autonomy of the different branches that are usually distinguished in this theory. So this focus on autonomy is especially obvious when we look at the Code of Ethics of MPs and ministers. When in 1997 the Flemish Parliament was the first parliamentary assembly to set up a commission of ethics and to adopt a code of ethics for the members of this assembly, the argument of the separation of powers was not invoked yet, though. So, facing the thesis that it was unacceptable that MPs would be judged by their peers and that the members of the commission would defend the members of their political groups in a partisan manner, selecting a commission only comprised of MPs was justified in comparison with the commissions of ethics of a profession such as lawyers, where it is a tradition that members are judged by their peers. But when the Parliament and the Senate assessed the Code of Ethics of political mandates, they challenged the legal nature of these Code of Ethics and the competence of assemblies to adopt them. The Scientific Committee referred to Article 60 of the Belgian Constitution, guaranteeing the internal autonomy of legislative assemblies. According to the constant case law of the Council of the State, this provision guarantees the independence of each assembly, one towards the other, and as well from the executive power. So it's not up to the law to take action to select the way the chambers use their powers or make their decisions. So the law cannot set up a parliamentary commission only comprised of MPs. And it's important to mention that, only comprised of MPs. This is not up to the law to say this. And there will be other commissions where the law can intervene because these commissions are comprised of external members. So, those rules of ethics, are they rules that determine the way each assembly carries out its responsibilities according to Article 60 of the Constitution? The Scientific Committee of Political Renewal Commissions makes a distinction between internal ethics, the rules that concern the MP working methods, and the external code of ethics, the way some members behave in their relationship with the outside world, and especially during individual services rendered to the population when they when they have meetings with citizens. So according to the Commission, the internal code of ethics is the exclusive field of assemblies. It's not the case for external code of ethics. This could be governed by law, and in the absence of such a law, the assemblies could take action by regulations. But the parliamentary regulations cannot adopt sanctions that would be similar to the civil code sanctions. The rules of ethics should be limited to disciplinary sanctions. This distinction between internal and external code of ethics was not maintained in the opinion that the Council of State rendered on the January 6, 2014, setting up the Federal Ethics Commission. This law sets out a commission of ethics comprised of magistrates, scholars, former elected representatives, and aims at drafting a code of ethics and to make decisions for federal MPs, ministers, and secretaries of state. So this council validated the proposal. And so even if the Commission can draft a code of ethics, it can be applied to the members of the Assembly and the Senate only if it's included in their rules of procedures. Each Assembly is thus sovereign and is not bound by this project. And in practice, the Chamber and the Senate did not wait for the setting up of this commission to adopt their own code of ethics. As for the other competence of this commission, which is to render opinions on individual questions or general ethics questions, the Council of State decided that it's only a consultative role, and these opinions are not constraining for anyone. Indeed, they are only there to shed some light on those requesting this opinion and should not be used to complement or amend the code of ethics adopted by each of the two assemblies. The Council of State applies some similar principles to ministers and civil servants, underlying the autonomy of the executive power in the setting out of ethic rules concerning itself. And so the code of ethics that the Commission proposed cannot apply to ministers and federal secretaries of states, and they can ask and the opinions that they might ask are not binding. In further opinions, the Council focused on the autonomy of the legislative chambers, and so the Council of State decided that it would not be receivable concerning the autonomy of assemblies granted by Article 60 of the Constitution to entrust the Federal Ethics Commission an authentic interpretation of the Code of Ethics of the Chamber and the Senate. During the setting up of a Brussels Commission of Ethics, the Council of State opposed the fact that the Brussels regulators wanted to make this Code of Ethics established by the Federal Commission applicable to the members of the Parliament of the Brussels region. It is indeed up to the Brussels Parliament to set up their own code.
The accent meant at the level of the separation of powers meant that the level of the executive, the different bodies adopted their own codes of conduct by way of regulation. As already explained, the Flemish Parliament was the first to do so in 1997 when they adopted a code of ethics on services to the public. It was followed by the House of Representatives, which adopted its code of ethics in December 2013, and by the Senate, for which the adoption of the code of ethics was part of the new regulation adopted as part of the sixth reform of the state. In each case, these are regulatory acts adopted by each assembly separately. And the same will apply to the Walloon Parliament, the Parliament of the French Community and the French Community Commission, and the German Community Parliament, although they have not adopted any type of instrument until now. So that is something specific regarding the Brussels capital region. After the adoption of the it is also clear from the cooperation agreement that for the Brussels region, and on the 14th of December 1997, it was compulsory to draft a code of ethics applicable to its members. And although this text is related to a draft code of ethics, we thought that this project would be implemented immediately, i.e. without any inclusion within the regulation of the Parliament. The Brussels Capital Region Parliament did ignore, to a certain extent, the opinion of the Council of State. And the Council of State clearly indicated that the separation of power was to be respected. At the executive level, we had a similar situation. After the action was carried out at the level of the autonomy, the Code of Ethics was also adopted on the 20th of June 2023.
L'accent qui a été mis sur la séparation du pouvoir lors de l'établissement des codes et des commissions de déontologie a eu comme conséquence
the emphasis placed by the Council of State on the autonomy of the executive, the federal government adopted its own ethical rules with the Code of Ethics for members of the government. And this issue is indeed applicable to the Federal Committee in charge of ethics. It is a parliamentary committee which is made up of magistrates, university teachers and former elected representatives. The powers of this committee are the following. They can issue opinion upon a request of public administrators, ministry, or the Federal Public Service. It is also invited to issue opinions on a general basis, except on specific cases, or it can be done upon a request of 1/3 of the members of the Senate. When a problem does arise in terms of ethics regarding a member of the Chamber or the Senate, the member in question is the only one who is entitled to refer to the committee. Another member of the Assembly or a third person cannot submit this individual case to the committee. 1/3 of the members can ask for a general opinion, but this request cannot be related to a specific case.
Cette limitation a abouti à demander assez artificiellement à la Commission et à la Régie générale, alors qu'il s'agissait manifestement
Of course,
d'un cas individuel.
as a result, an ethical problem arises with regard to a member of the Senate, or in case we would have, we had the limitation which has resulted in the Commission asking for quite artificially for a general opinion when it was clearly an individual case. For example, when it was revealed in 2017 then that the chairman of the chamber, Siegfried Bach, sat on the advisory board of Telenet, a television broadcaster, had received a remuneration of 12,000 a year and €2,000 per meeting. The Ethics Committee was asked for an opinion that included the following general question: in view of the status of the Speaker of the House of Representatives, which guarantees him special authority both in financial terms and in terms of the prestige of protocol, should not be considered to guarantee the independence of his office by refusing to hold any position, whether remunerated or not, that would place him in a potential conflict of interest. The committee ruled that the request was fully acceptable. When a member clearly breaches the Code of Ethics of the House of Senate, it is therefore not possible to refer the matter to the Ethics Committee, except by this request for a general opinion. Nor does it seem possible to refer the matter directly to the Assembly in question. In fact, although under Article 163 of the House's Rules of Procedure and Article 74 of the Senate's Rule of Procedure, members of these two assemblies undertake to comply with the Code of Ethics appended to the Rules of Procedure. But the Rules of Procedure do not provide for any sanction mechanism in respect of a member who does not comply with this undertaking. This appears to be a deliberate choice on the part of these assemblies. Indeed, when the Chamber's Code of Ethics was adopted, the absence of sanctions was justified as follows. The Chamber's Code of Ethics is thus one of a series of standard-setting instruments that can be used to bring about changes in behavior without, however, being accompanied by sanctions. The progress made in terms of ethics, thanks to the Code of Conduct for Flemish MPs, has not been hampered by the absence of sanctions for the behavior that the Code does penalize. This is a surprising statement, given that a few years earlier it was deeply regretted that a legislative assembly could not take action against an MP who abused his office. In 2002, a senator, Jean-Marie de Decker, visited Marc Dutroux at the prison of Arlon. The senator made use of the right of members of parliament to visit prisons, but he was accompanied by a journalist without the prison staff being informed about that. Following the incident, the Senate adopted a motion condemning the abuse of parliamentary privileges and asked the Bureau to take immediate sanction against the senator concerned. However, the Bureau was obliged to note that in the absence of legal or regulatory basis, it was impossible to impose any sanction whatsoever. The Code of Conduct of Flemish MPs, on the other hand, does provide for a penalty under the third paragraph of Article 35 of this code. If the committee finds that the Code of Ethics has been breached, it can publicly reprimand the MP concerned. Furthermore, unlike the federal level, the Code of Conduct for Flemish MPs offers greater scope for lodging complaints. The same Article 35 stipulates that a Flemish ombudsman, judges, civil servants or other persons faced with interference by a Flemish MP might report the matter to the President of the Flemish Parliament, who will forward the complaint to the Ethics Committee. Only anonymous complaints are not accepted. However, the problem of the effective application of the Code of Ethics at the level of the Flemish Parliament lies at other levels. On the one hand, there is the limited scope of this code. As I've already mentioned, it only concerns services rendered to public, rendered to citizens. So it is not applicable to the behavior of MPs in general. The Ethics Committee of the Flemish Parliament seemed to have lost sight of this recently, so there is a lack of transparency. And in spite, under Article 7 of the internal rules, only decisions by the committee have to be, for example, a reprimand, are justified and pronounced in open session. When the committee declares a complaint is not admissible or dismisses it as unfounded, it remains to be seen that what are the committee's reasons. For example, in the case of Mr. Crombet, that I mentioned at the very beginning of my speech, it was only only on the basis of these unofficial statements in the press that we were able to find out the Commission's reasons for rejecting the complaint. Moreover, in practice, when the committee issues a reprimand, it does not draw up a parliamentary document setting up the reasons for its decision. Instead, all that is issued is a statement by the chairman in a plenary session to the effect that the committee has decided to reprimand one of the members of the Assembly. Such an approach contradicts the idea that the purpose of the MP's professional ethics is not only to ensure that the Assembly functions properly, but also to guarantee public confidence in the institution. It is important to have this possibility to act in individual cases. As part of the fourth evaluation cycle, the �GRECO recommended that compliance with the rules on parliamentary integrity contained in the codes of conduct should effectively be monitored by the legislative assemblies. And in the very last compliance report, �GRECO did consider that those recommendations had not been fully implemented. The principle of the separation of powers does not prevent this from being the case. Thus, there is nothing which does prevent the Chamber and Senate from incorporating sanctions into their Code of Ethics, as it is the case with Article 35 of the Code of Ethics for Flemish MPs. Until now, the only possible sanction under this provision has been a reprimand. But it is possible to imagine other sanctions of disciplinary nature, such as a deduction of salary or, in extreme cases, temporary exclusion from the Assembly building, which the rules of the Chamber and the Senate already provide for as a disciplinary sanction when a member, for example, disrupts the order of the Assembly. It follows from the case law of the the Council of State that by virtue of the separation of powers, such a disciplinary sanction must be imposed by the Parliamentary Assembly or by a Parliamentary Ethics Committee, as it is the case at the Flemish Parliament. But the Federal Ethics Committee or Commission, which is not a parliamentary body in the strict sense of the term, and is made up of magistrates, professors, and former elected representatives, could not give such a decision-making power. The same applies to the Ethics Committee of other regional assemblies, which are shaped in the same way. But the separation of power does not preclude the fact that prior to Parliamentary Assembly's decision to impose or not a disciplinary sanction, the Federal Ethics Commission examines whether there has been a breach of the Code of Ethics. Such a mechanism, and I will conclude there, is similar to what we have in the Netherlands, where the Integrity Inquiry Board, made up of 3 experts, decides only whether or not there has been any breach of the Code of Conduct for members of the House of Representatives. And sanction is left to the House itself. In this way, we can have an effective sanction mechanism while respecting the separation of powers. It could serve as a model for the Belgian Parliament. Well, I would like to thank you for your attention.